Yeah, so the reason why we're here today, so we have the MOUs, which is great, and they set a certain kind of rules, well, not rules, because they are all voluntary, yeah, but standards that the signatories should follow. But already, even before the MOUs here in Philippines and in Thailand, but also in the EU, you had certain intermediary services who had already implemented quite a lot of good practices in terms of terms and condition and KYBC and such rules. But we have new legislation, at least in the EU, so the Digital Service Act, that will probably, if not reaffirm what intermediaries are already doing, but they might have to adapt their own terms and condition or KYBC or other regulations that they have to adapt. Some of them actually might go further than the DSA currently, but at least there are already existing good practices. But the MOUs kind of take this further, at least when it comes to information sharing and those type of voluntary collaboration that isn't regulated by any law at the moment. So the way we have divided in these good practices that we have identified is in 3 blocks. So preventive measures, i.e. something that you do before an occurrence. Reactive, so if someone tells you something. And then collaboration. And we don't put any value into this, it's just a way to structure for the paper that made sense to us at the moment when we wrote them. I will also mention the DSA. It's a European Act, but it's quite important for actors who qualify for the DSA to know about the rules and what they have to kind of comply with if they run a business within the EU. Anyway, so if we start, so preventive. And I think one expert kind of set the ground in one of our first papers saying all good practices starts with terms and conditions. And it's fairly true, yeah. All these intermediary services, not just online services, but transport and logistics, they all have some type of terms and condition that you have to kind of agree to when you use their services. Even if you haven't read them, and I'm pretty sure, well, I don't most of the times, but I'm pretty sure that the counterfeiters and the illicit players, they don't, or they do maybe to find loopholes. As I said, most of these intermediary services have some type of terms and conditions. Some even have different terms and conditions depending on their service. So if we take the app ecosystem, for example, they will have terms and conditions towards their user, but they also will have terms and conditions between the App Store and the developer of apps. And you also have terms and conditions between the developer and the user of the app. So just to kind of find out who is responsible for what, if we're talking about liability, is quite hard in the app ecosystem at least. Because it depends on the functionality of the app, where you download it. So if you have, for example, an app that uses user-generated content or content created by AI, in their terms and conditions, they actually stipulate that this content can't infringe any IP. So who's liable then? App Store, do they have a liability for what happens on that app? Maybe not. It might be the developer because it's in the terms and condition between the developer and the user. So as I said, it depends on what type of intermediary services and how many players you have within that ecosystem. So they have terms and conditions for various situations. These terms and conditions also contains different type of situations. So some of them have rules like repeat infringer policies, as we will see in the MOUs as well. Some don't. If we look at the DSA, they might have to, if they haven't done it already, but they have to introduce something like that. Some terms of condition actually contains specific rules about using other IP, not just the intermediary service's own IP, but IP of others. Whilst the DSA don't really touch upon the IP aspect, but they touch upon that you need terms and conditions to regulate the liability, but not so specific as to what content. Then most of the intermediary services have also rules about KYBC, so know your business customer, and user verification. And again, this is very dependent on what type of intermediary service we're talking about. What comes to mind is the latest study we did on apps and app stores. Some of these app stores are actually very due diligent when it comes to verifying their users and requesting photo ID at some point. They can request, if you're a business, they can request your business registration number. Some uses is a combination with payment verification. So you need to actually create, submit your credit card or some type of payment information to verify that part of your business as well. ID verification can be done in-house, but they can also use third-party services for that. And as I said, some of the app stores do this, but some of the less, well, not the big ones, but the smaller ones might not have as strict rules when it comes to KYBC. For example, transport and logistics is also very due diligent when it comes to their KYBC or know your business customers. They and payment services as well. Payment services have their own kind of internal. It's a collaboration between payment industry, but they have this terminated merchant files, whereby they list people that have acted fraudulently, and they check against them before they create an account for them again. Transport and logistics have a similar kind of list that they share between them. Monitoring and internal risk assessment system. So transport and logistics, they have actually, but that's more given their nature, they have their own kind of risk assessment system when they receive a shipment. And there's different parameters. They use keywords, they use routes, a lot of different type of information. But it's not, sad to say, not just because of IP infringement, but mainly because I think they don't really want to transport goods that is dangerous. So they don't want to risk something happening whilst they're in transit. As I said, payment has their merchant monitoring program and the terminate merchant files, which is a collaboration between payment providers, and they use this system to kind of monitor their clients. Social media, not all of them probably, but some of them have different type of system and tools in place to kind of find out. So if one of your accounts have been banned, you can't just create a new one. And it's It's more sophisticated than just checking the email. It's a lot of checks that are being done just to try to find out so they can't create an account of an already banned user. And then you have specific measures. So these are kind of, it's not across the board. One example is the domain name industry. So when you had the new generic top TLDs introduced back in 2011, I believe, 2012, there was a trademark clearinghouse set up. So you could, as a right holder, you could submit your trademarks, and you had certain rules. So depending on what stage you were in the release, you either was first on the ball, so you could register your domain name with your trademark, or you could get notification if someone tried to register something similar. But that is a specific measurement just for that occasion. Reactive. So I think we touched upon it. So notice and action. And that's something that we can see in the MOUs. And that's definitely something that we can see in the DSA that is becoming an obligation. And most of the intermediary services, when it makes sense, have some type of notice and action mechanism. So, but it's also depending on where you are and in what jurisdiction, what is required. So if you need to submit a trademark, do you need to submit it as a national trademark? Can you file several notice and action in one request, or do you have to do separate ones? So it much varies depending on the intermediary, which is a challenge for right holders as well, just to be able to know all of this. And it's a lot of information out there. And that's, again, just to promote our own work, the repository that I mentioned in the beginning that we created for the IP protection programs for e-commerce, that was the intent was to help right holders find the right kind of IP protection programs for these different e-commerce. Because I don't know if you have any experience with it, but depending on e-commerce platform, you need to go to local websites to file your request to take it down, depending on where you find it. So there's no, they're getting better, but there's no central kind of point where you can submit different notice and actions. Well, depends on the platform, I should say. Trusted flagger schemes. So already e-commerce and social media search platforms already have this type of scheme, and it's a trusted flagger scheme. So what does that mean? It means that basically, in simple words, is that if you're a trusted flagger, they trust you in the sense that they don't do that much pre-checks. So if you file a claim, they kind of trust you that you've done your due diligence and it's actually a proper IP infringement. If I file a notice in action, they might actually want to ask me to provide more evidence and all of that, but this trusted scheme is supposed to make it easier and quicker. It's also one of the rules that will be obligatory under the DDSA. So IP protection program, so again, our repository. So it's not just about the notice and action. It's actually, these programs give you tutorials, kind of help you how to file, how to think when it comes to an IP infringement. They also have these programs, you can call them that, where you submit your brand and you give them information, and they proactively scan their e-commerce for you and take down listings without you having to notify them. I think I think Alibaba and Amazon has them both, if I'm not mistaken, at least Amazon, whereby they proactively do this without you having to do anything. Well, apart from signing up to that program. And then, just as I mentioned earlier, so when it comes to apps, it's a different type of nature there, because, as I said, even if you take it down from the store, it doesn't disappear from the device that the app has already been downloaded to. So people will be able to access it still. What certain app stores have done is that they can send out alerts to people who have downloaded this, saying, we have now removed the app from our app store, so there's something fishy with it, so you should also remove it from your device. Doesn't mean that they do that. In some cases, we've seen that they actually removed the app from the device as well. And I think it's Google who has been. There's a case in Brazil, if I'm not mistaken, where the court have actually said that they should remove an app that was used to live stream sports event. But it's not a final outcome, so I can't tell you what's happening there. But that's actually a court case ongoing. And then when it comes to collaborations then. So these are more voluntary collaborations between different stakeholders. So you have between intermediaries themselves, between the intermediaries and right holders, sometimes law enforcement authorities and right holders, intermediaries, or them all together. And it could be different type. We've seen, well, different types of collaboration. So we've seen examples of where customs agents are collaborating in a region, doing specific targeted actions on specific type of goods. We've seen right holders and law enforcement authorities collaborate in certain actions as well. But then you have initiatives like EUIPO alerts as well, from EUIPO, which is all good and well when it comes to this. And then, of course, we have the MOUs. So we'll hear more about the MOUs. I'm not going to go into them in detail. We'll have representative from the Commission, from the Thai office and the Philippine office, discussing more about the MOUs. So I'm not going to go through them, but it's a very good instrument to gather all stakeholders, to discuss and to see what can be done in the future as well. And I think we're going to discuss that more in the panel discussion. But they need to be kept alive, and everyone needs to be involved in the information sharing that is prominent in these MOUs. So, very good initiative, and I congratulate you for being able to do it here. And then lastly, legislation. So this is not a good practice per se, because it's an obligation. So it's kind of wrong to classify it as a good practice. But it's something that people should be aware of, at least when it comes to the EU. I'm not entirely sure the legislation in Southeast Asia, but when it comes to the EU, we have the new Digital Service Act. And if you fulfill the requirement to be obliged to follow the DSA, I mean, social media app stores are certainly qualified, e-commerce as well. Depending on your size, you have additional obligation as a very large online platform. But certainly you have rules. As I said, Article 14 talks about terms and conditions that needs to be adapted by the online platforms. You have Article 15, where you have to, which isn't done that much today. Some already do this, e-commerce amongst others, but every year you need to create a transparency report talking about your infringements and what's happening on your platforms. Article 16 has the notice and action obligation. And then for online platforms such as social networks and app stores, you have certain articles about trusted flaggers, and when it comes to ads, you need to specify where those ads are coming from. So more transparency rules. And then online marketplaces also have to have something called traceability of traders, which is basically your KYBC. Yeah, I know I have 10 more minutes, but at this point I wanted to open up the floor and see if you have any questions, maybe online, I don't know.